Good morning, good evening, Shavua Tov. I'm Doug Altabeff, Chairman of the Board of Im Tirtzu, and I want to welcome you to what I am confident will be an educational and compelling discussion. Before
Recording
I
in
introduce
progress.
our illustrious panel, I want to touch on a couple of points. First, I want to thank the many organizations that have joined with us in co-sponsoring today's event. Your participation and your support are very much appreciated. Secondly, I apologize in advance that we will not be taking questions from attendees, but by way of compensation, hopefully we will be touching on many of the issues that most of you would have liked to have asked about. Thirdly, just 5 minutes ago, we were given the word that MK Simcha Rothman will not be able to join us, which is a great disappointment, but as Professor Kontorovich pointed out, not a great surprise. It's a very, very intense time, as we'll talk about this lead up in this week coming before the recess of the Knesset, and my understanding is MK Rothman was in a very, very intense meeting that he could not extricate himself from. But I'm confident that we will get a lot of very, very astute information regardless of the fact that he will not be with us. And finally, I want to take a moment to explain why we at Im Tirtzu sought to have today's conference. It's quite clear that we have played a visible and I believe impactful role in supporting judicial reform, especially considering our rather modest financial resources. Many people have said to us, you guys and the right, you've won. The vast majority of the country, including many of the loudest and leading voices in the opposition, have either now or in the recent past accepted the need and the desirability of judicial reform. Some kind of reform. In fact, I would go even one step further, and I would say that there are increasingly few people who will deny that any change is needed and that things are fine just the way they are. These are the judicial flat earthers, and fortunately they are becoming an endangered species. Fair enough. But this is not the Oxford Debating Society, it's the State of Israel. And the apparent need for reform inevitably becomes the rubber meeting the road of proposed legislation. That's where we are now, and these proposals have engendered strong feelings pro and con. As Israel's largest grassroots Zionist organization, we at Im Tirtzu have a commitment not just to reform, but also to our social fabric. We seek to have the issue of reform devoid of the threats, intimidation, and fear-mongering that have accompanied some of the opposition to these proposals. Opposition, of course, is expected and warranted, and it has become increasingly clear that the deeper motivations and agenda behind the opposition extend far beyond the four walls of the reform proposals themselves. However, demonization and delegitimization, not to mention the prospect of civil unrest, should not be part of the disagreement. Simply stated, mob intimidation cannot be the way we run our country. So our goal for today has been to attract a broad range of viewers with a broad range of opinions. We hope to provide answers to questions, clarity, and above all, light instead of heat. With that, I'm most pleased to welcome our panel, which, even without MK Rothman, defines an A-list of participants. With us is Professor Eugene Kontorovich, a highly regarded international legal scholar and a senior member at Kohelet Policy Forum, which has played a leading role in helping to formulate and to advocate for the proposals. Thanks to Eugene and Kohelet's strong involvement in the formulation and rationale for reform, I am hopeful that he can provide many of the insights that we would have looked to MK Rothman for were he with us. Finally, it is a great pleasure to welcome Judge Michael Mukasey, one of America's leading jurists and a former Attorney General of the United States, under President George W. Bush. So let's get started with a little bit of context. One of the controversies surrounding the proposals is that they seemingly sprang from nowhere, and that there was this sudden rush to make something happen. Of course, this is not the case, and there is a history here which I think we should be apprised of and reminded of. Eugene, could you give us a brief summary of some of the most serious steps that the court has taken over the years to aggregate its power and to expand its discretion and to bring us to where we are now? I think you were on mute. There you go. No. No, still on mute. Hold on.
Thank you.
There you are.
Anyway, thank you. Pleasure to be here with you, Doug. Pleasure to be accompanied by Judge McKasey on this discussion. And thank you all in the audience for being here on a Sunday, taking time to more deeply understand this important issue. The push for reform of the powers of the Supreme Court is not new and has in fact been part of the agenda of the right for a decade or more. My own think tank, I can tell you, was founded a decade ago in part by the result of the crisis, the democratic deficit, the democratic deficiency that already existed because of the actions of the Israeli Supreme Court. And there have been numerous legislative proposals over the years to even make modest reforms to the court, all of which have been shot down by the legal elites. So this is not a new issue. Even in 2016, Yair Lapid said, the power of the court to decide any case, without standing is intolerable. Gideon Sar has spoken out against it. So this is not a new issue, and it did not spring out all at once. I would, in terms of the timing, I think it's important to remind people that Israel has had 5 elections in the last 6 years. In other words, there's been a period of extraordinary government instability. And that would make the past 6 years just a time when serious legislative initiatives like this could not have started. So let me explain a bit about the need for these reforms and what the status quo is. Because the status quo is itself a significant problem for democratic self-governance in Israel. In Israel, the Supreme Court has powers unlike any court in the world. So to start off with, Israel does not have a written constitution. It has what's called basic laws, which are not constitutional laws because they're not passed by a constitutional process. So you might have heard of basic laws, but what's important to know is they're passed by a pure majority. In other words, you can have a basic law that's passed 2 Knesset votes to 1 if they decide that's a quorum. Indeed, so the default in Israel is what's called parliamentary sovereignty. That is not an unusual thing. That is the case in most British-based parliamentary models. In other words, court traditionally has not been able to fundamentally override the parliament because the parliament represents the people, and the people are sovereign, right? just like in the United States. So the Knesset in 1995 announced that a basic law that had been adopted a few years ago, called Basic Law Human Dignity, gives it the power to strike down laws of the Knesset, and in fact gives it the kind of judicial review powers that the United States Constitution confers on the Supreme Court. Now, in Marbury versus Madison, when the Supreme Court formally announced that it has power over judicial review, it explained it very simply. We have a written constitution, someone has to interpret it. Israel doesn't. The Supreme Court gave itself the power of judicial review, at least in certain matters mostly dealing with human rights. If they had stopped there, I think it would be illegitimate, it would be an usurpation, but we would never have gotten to this crisis. They did not stop there. Also, throughout the 80s and into the 90s, the Supreme Court got rid of any restrictions on who and what kind of cases it can hear. In America, courts can't just decide general policy questions. They can't decide questions about foreign relations, about military tactics, and certainly not about the actual discretionary political choices of the government, like who can be a cabinet minister. In Israel, the court got rid of any of those limits, so anyone can basically bring a case in the Supreme Court saying, I think the government is doing something wrong. And the Supreme Court can review that no matter what and decide whether they agree. Things like who can be a cabinet minister, who can be appointed to government positions, what the path of the separation barrier shall be, and so forth. Refugee quotas, there was an amazing case recently brought by the Ukrainian ambassador to Israel, challenging Israel's quotas on Ukrainian refugees, a case that could never be brought in United States courts. So they basically made themselves a roving commission with a mandate as broad as the legislature to decide any policy issue. If they had just stopped there, we wouldn't be here. Then they went on and said, aside from striking down laws because they conflict with this other law that they claimed is constitutional, they can also stop any government action, not legislation, but action, administrative action, because they disagree with it, because it's unreasonable. Now, in America, when a court reviews government action for reasonableness, they say, could a reasonable person have made this decision even if we disagree? Would you have to have been crazy to make this decision? In Israel, it's almost the opposite. Right? They say, would we be unreasonable to decide it should be different? No, we wouldn't, so it should be different. And under that auspice, they have vetoed vast numbers of government actions. If it had stopped there, we wouldn't be here today. The court only hears 10,000 cases a year. It's a huge number. It's a huge number, but that does not give it the power to control every single aspect of political life. So what they did is they created a doctrine. Again, none of this is based on law or statute, where the Attorney General, who is not selected, by the government, selected by a bureaucratic committee, and then appointed by the government, a committee on which the Supreme Court is represented, in which they have a functional majority. So he's essentially a commissar of the Supreme Court in the government. The Attorney General can veto any government action, not through a formal veto action, but by sending basically a one-sentence letter saying the action is problematic. They need not have legal argument. And that action is dead. If the government wants to do it anyway, the Attorney General will not represent the government in court, will argue against the government in court, thus depriving it of legal representation, and can prevent the government from hiring private counsel. This is almost more important than the Supreme Court part, though it was done by the Supreme Court, because it allows any single government action to be blocked at any level of government. And this is paralleled at every level of government by each government's general counsel, who is not answerable to that government, but only to the Attorney General. So there is an entire parallel bureaucracy throughout the government of legal officials answerable not to whatever department they're in, but to the Attorney General, who can veto government action for no particular reason. Then it's starting to get serious. More recently, the Supreme Court went even further, and this was just in the past few years. Traditionally, if you criticize the power of the Supreme Court, what the defenders of the court, Israeli law professors, would say is, the Knesset, even if they didn't explicitly grant them this power, obviously they acquiesce to them having these powers because they can always make a basic law changing things. A few years ago, in the nation-state law case, the Supreme Court said they also have power to review amendments to basic laws. In other words, they're claiming they can strike down what they call constitutional provisions, as unconstitutional.
Right.
That there was an unwritten higher constitution,
Right.
and it's like if the Supreme Court could reject the 14th Amendment after Congress passed it, could say, you know what, we don't like this.
No, that is an absurdity that many people have jumped on, and with that as a parting shot, so to speak, Michael, I want to ask if what Eugene has just said, and I'm sure he could go on with a lot of more examples, but just what you've heard, has he made a prima facie case for the need for judicial reform? And if so, what jumps out at you as being most in need of attention and redress? You too, Michael is also on mute. Hold on.
Can you hear me?
Yes, now we hear you. Thank you. Sorry.
He's made at least a prima facie case, and what jumps out at me is the strangeness of stepping into a system like this after having been used to the system in the United States, where courts are constrained by a written constitution and by doctrines that of what is suitable for what is justiciable. That is, what is suitable for review by a court and what is not. That's a very important concept, certainly in U.S. courts. The court will not consider matters that it considers political questions. It will consider only, and this is a constitutional principle, cases and controversies. That is, actual disputes between actual people or entities where somebody has an interest. You can't simply go into court and decide that you want to claim that the government has done something wrong. But it will decide only cases and controversies, and will decide only matters that are justiciable. That is, matters that can be decided by reference to an objective standard. What is reasonable and what is not reasonable is not an objective standard.
Right. Right.
So what you have here is a group of people who have essentially set themselves up as philosopher kings to decide what should or should not be done. When you join that with the unconstrained power of an attorney general, who in the United States is supposed to represent the government and defend the government's interest, but apparently in Israel is not bound to do that, and in fact can oppose the government and deny the government any legal representation by refusing to permit them to hire private counsel. You have a situation in which the Attorney General and the Supreme Court essentially exercise at least a veto power over everything that happens in the country.
Right. So for the purposes of our audience, let's just zoom out for a second. What the two of you are basically saying is the situation here is anomalous. It is uniquely anomalous, and it defines a need to bring back some balance, a need to bring back, we talk about checks and balances, and one might even say some sanity, because, as Eugene pointed out, this is discretion run amok, and it is decoupled from, as you said, Michael, any objective standards. So, Eugene, let's look at, rather than looking at each individual proposal, first of all, can you give us a sense of what the goals, when the smoke clears, and if reform is done reasonably approximating what the proponents would like to do, what are the goals that they would be hoping to have accomplished?
The goals are basically to introduce a modicum of democracy into Israeli politics, and to create checks and balances. So everyone says checks and balances are needed, right? That's one thing everyone says they agree on. But nobody can identify any checks on the court. Now, there are simply none. So on one hand, they wield vast power, and can annul the decisions of democratically elected legislators. On the other hand, they are completely outside the democratic process. So the goal is to so currently, half of Israel feels that elections don't really matter for them. And that's a terrible feeling. That there's no way that their input can be felt, because if a left-wing government is elected, they will naturally implement left-wing policies, which is legitimate. And if a right-wing government is elected, they won't be able to implement right-wing policies because of the Supreme Court's political slant. And I think now we need to touch on a crucial point: how the Supreme Court is selected, which is also unique and is perhaps the most problematic thing. In America, this is why I think judicial reform is in the long run absolutely crucial to social cohesion. In America, let's say the Supreme Court makes a big and important decision that much of the country regards as mistaken. Take Roe versus Wade, for example. They don't have to say we're moving to Canada. They don't have to engage in civic unrest. They can say there's a democratic way of dealing with this, which is slow, right? Which is not radical, because you can't just throw out a decision of the court, but instead you can vote for presidents who are going to appoint judges who are committed to a judicial philosophy that is different, and hope for a different result. It will take decades. And same thing with Dobbs, right? If you don't like Dobbs, you can say that we're going to do the same thing and vote for presidents who are going to appoint justices with a different judicial philosophy. In Israel, you can't do that, because the judges control appointment to the court, and they have a veto over their own colleagues. So if you were the court who decided Roe versus Wade, would you allow on judges that are against Roe versus Wade? No. So, and vice versa, right? So in effect, there is no Justice Scalia on the Supreme Court, right? There could never be an Amy Coney Barrett on the Supreme Court.
Right.
We're getting a lot of comments in the panels. I just have to say they're a little distracting. So
that's
try
okay.
To
the current selection process.
So the current selection mechanism is controlled by the court itself.
Right.
And on one hand, the court has vast power. On the other hand, it appoints itself. And what does judicial independence mean? I'm sure Judge McKasey can talk to this. In America, judicial independence is life tenure, right? That you can't fire them, you can't change their salaries. Right. In Israel, no one is talking about changing that. That's in the books. No, the only question is who appoints them initially.
Right.
And no one is suggesting that the current government should appoint all the judges. Right. The suggestion is, when this government is in office, it should appoint at least some of the judges, but not too many. And when the next government is in office, it should do the same thing. Anything but the judges. And the position of the opposition is no. It's sacred that the judges control the selection of the judges. And the question to ask is, if the judges, this I think is the best proof of the political bias of the judges, would we think that the political opposition would support the judges forever picking themselves if the judges were ruling with the Netanyahu government, or if they were, even 60% of the time on the side of the Netanyahu government? They'd say, no way, now let's make it even. Mm-hmm. So I think, that is why the opposition is fundamentally against any kind of change, because why should they give up total power over everything?
Right.
That's why this notion of compromise, I think, is elusive. Right.
Well, we'll get to that. But
who has total power? Why should they compromise?
Right. We'll get to that. But the selection process, and correct me if I'm wrong, is slated to be considered this week before the Knesset goes into recess, to be voted on this week. And Justice Minister Yariv Levin, who with Simcha Rotman has been the two major drivers of the process, has said that the bill, which was tweaked by Simcha a bit to make it a little in the views of the opponents a little less onerous, but that the bill, if passed, would accomplish four principles. Number one, as you pointed out, it would allow the government to have majority control to appoint at least the first two justices. Number two, it would end the judicial veto over selection. Number three, it would end eliminate the Bar Association's participation in the process, because the Bar Association was seen to be highly conflicted and basically a shill for the justices themselves, a built-in voting power for the justices themselves. And finally, it would change the process, the selection of the president of the court, from an automatic seniority process to one where the government would decide who the president of the court would be. So, first of all, Eugene, I would ask if you would agree that these are principles that would grow out of the bill. Are they desirable? And as you were sort of hinting at, and I would certainly also say, many supporters of reform would call this proposal the sine qua non of the whole initiative, the must-have, the essential proposal, because over time, all of the benefits of judicial reform would flow from a more balanced, a more diverse, a less of a terrarium, type of court. So, if that's the case, does that make this one the real got-to-have proposal?
It's interesting. When the government first proposed its package of judicial reform proposals, right, there was a proposal dealing with the Attorney General, with the reasonableness doctrine. Everyone said that the problem is what was called the override clause, which let the Knesset temporarily suspend decisions of the Supreme Court, like in Canada. And indeed, it's something that's weird to American ears. And over time, the government, and the criticism was, you're doing too much. It's too many pieces to this proposal. In the end, the government is going to have, power to damage minority rights. And that, of course, was not what the government wanted. So the government wanted to compromise. The problem was the opposition didn't show up to compromise talks in the Knesset. They refused to negotiate in the Knesset for weakened legislation. So the government said, we're going to compromise ourselves. Right? We're going to negotiate against ourselves. We will put off or suspend basically indefinitely. When people say after Pesach, that means never is another way of saying it. Achrei Hagim means
yes,
literally a colloquial expression for some other day. The other proposals, and we're just going to do this technical thing, right? Surely people were talking about human rights. Surely there's no human right to have the lawyers and judges pick the judges. That's not a human right. Generally we think that rights are protected by having rotating democratic governments pick them. So that is in fact the sine qua non. The point about the Chief Justice is very important, the president of the court as it's called. In America, of course, the Chief Justice of the court can be picked directly by
the President of the United States.
But in Israel, actually, they have a process of picking themselves, which is a seniority-based process, which is not based in any legislation. Right. It's not even a judicial rule. It is a custom of the Supreme Court that they are now claiming has constitutional status and cannot be changed, perhaps by the Knesset. The reason this is really important is because their Supreme Court president has vastly more power than the American Chief Justice. Right. In particular, they can assign judges to cases. And since there's 15 members of the Supreme Court and they sit in 3-judge panels, even having 1 or 2 or 3 or 5 conservative justices on the court doesn't really help much so long as the presidency, right, is in the hands of the judicial establishment, because they can assign important cases to panels as they see fit, and that is a very important power.
Right. So, Michael, I'm very interested to get your perspective on this, because you have an unparalleled one here, both as the former chief judge of the Federal District Court of the Southern District of New York, arguably the most prestigious district court in the United States, but also as the Attorney General of the United States, where you were required to advise and closely interface with President George W. Bush. So you've seen jurisprudence on the ground, so to speak, and also as it relates to the functioning of another branch of government. So from your perspective, how does this all strike you? Here you've had a process where, if we walk through all the numbers, the court effectively has had a veto over who would be appointed to the court. And when we talk about, like, a self-referential terrarium type of thing, that's what you've had with the court. And now the idea is to break that, and to move the onus of responsibility to the legislature, because it's, as Eugene said, checks and balances. There are no checks. This becomes a check. And I'm particularly interested to hear what you think about the issue of choosing the president of the court, because one could argue that this is tampering with the internal machinations of the court, but Eugene made a very, very salient point, and that is, in the United States, it's the president who specifically chooses the Chief Justice, and the justices have nothing to do with the idea of who becomes the Chief Justice. So what is your take on all of this? And would you agree that this becomes, in effect, the sine qua non proposal for effecting what will hopefully be a more balanced situation over time?
Well, I would think that it's basic to any proposal for reform that the process be opened up to some influence of the democratic system. In the United States, of course, justices of the Supreme Court are nominated by the president and must be approved by the Senate. That is a two-level political process. And then, of course, they serve, as the commission says, during good behavior. As I understand it, in Israel, once a judge is appointed, that judge can serve until they're 70 years old. Is that correct?
Yes.
Yeah.
Okay. So there is no more control by the appointing power in Israel over what a judge does or doesn't do than there is in the United States. There is independence of the judiciary in that respect. So far as the responsibility and the power to assign panels and cases, chief judges in the United States don't have that power. But on the Supreme Court, if the chief justice is in the voting majority, then that gives him or her the power to decide who writes the opinion. Mm-hmm. That is analogous to the situation that you have in Israel, I suppose, because the Supreme Court doesn't sit in panels here; they sit en banc throughout.
Right.
But the chief justice can decide who writes an opinion, provided that the chief justice is in the majority. I assume that once a chief judge or chief justice is named in Israel, that person would continue for the duration of their service. Is that correct?
Yes.
Yeah, that's
Even
correct.
under
And they also
under the new proposal.
They also assign panels on which they don't sit. In other words, all the panels.
Mm-hmm.
But they would continue to serve once appointed a chief justice. That person would continue to serve until that person was 70 years old. Is that right?
Yes.
In that capacity, then it's really a very minor, it seems to me, adjustment, or certainly not an anti-democratic adjustment, to say that in the first instance, the government that is in power when the chief justice is appointed can appoint the chief justice. The same as happens here when a vacancy occurs in the office of chief justice. So I don't see that as anything improper. Quite the contrary. And I should finally point out that even in the United States, there have been presidents who have appointed justices and chief justices who have then pronounced themselves disappointed with what those justices and chief justices do.
Right.
I'm not saying that would necessarily occur in Israel, but certainly there's nothing to stop it. Once someone is appointed to the court, they can, for the remainder of their tenure, decide cases as they believe they should be decided. And that's the very definition of judicial independence, and that would not be endangered at all by this proposal.
The current system in Israel is not replicated anywhere else in the world. Am I right about that, Eugene? You're an internationalist?
There's aspects that are replicated, but the combination of vast power and lack of democratic control is not replicated. And I just want to say something about the history of this. When people say, what's going to happen if we make these changes? So again, first of all, the reform is already not the reform. Now all we're talking about is whether the government can nominate 2 judges to the court that the court doesn't have to agree with. That's the question. Whether that is such a modest, such a compromise, and such an incremental change. And I want to point out that the current status quo was never agreed to by the people in any way. With the possible basis of their first action based on basic law of human dignity, everything else they have done has been absent any legislation whatsoever. So everyone says that we all agree that there should be a national consensus, things should be done by consensus. And I agree with that. Things should be done by consensus. And given the absolute lack of any consensus to the court's power grab, we should erase that and then, move forward. I want to say that, we're not talking about turning the clock back to 1948. We're talking about turning the clock back to 1995.
Correct.
And nobody was saying that Israel was not a democracy back then.
That's right.
That is, in fact, when all of this started.
Okay, so speaking of consensus, let's shift our focus to the reaction that the proposals have generated, particularly some of the arguments that have been made against them. In a great example of what I would call Orwellian projection, the opponents of reform, any reform, labeled the initiative as profoundly undemocratic. This seems definitionally strange since the proposals are put forth by a duly elected and constituted government representing the majority. However, what the opposition might mean is that they perceive the Supreme Court to be the sole guardian against tyranny by the Knesset, whether it is to destroy minority rights or to create arbitrary laws that would, in the opponent's view, represent a tyranny of the majority. I would ask each of you to address this mindset and these accusations, but before I do, I want to just quote something that Thomas Jefferson said, having to do with his very strong feelings about the potential for judicial tyranny. In a letter to Thomas Jarvis in 1820, Jefferson wrote, quote, "You seem to consider the judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so, and their power is the more dangerous, as they are in office for life, and not responsible as the other functionaries are to the elective control." So, Michael, do you have a sense, a take on this idea that only the Supreme Court could be the guardian against tyranny?
So long as there is a democratic system in Israel that produces a Knesset that passes laws, and the members of the Knesset are democratically elected, I don't see how there is a danger to democracy from any of this, number one. Secondly, a court has to have some objective standard to use when deciding cases. It cannot simply say that this is the result because we said so. It should not be able to say that. And if, to the extent that any of its decisions involved policy judgments, at the very least, people ought to be able to say that the judges appointed to the court were appointed with some consideration of what the political views were of the electorate in the large. They can't say that under the current system.
Eugene?
Yeah, I mean, the democracy is just a political slogan at this point, right? It has no more meaning. George Orwell wrote in Politics in the English Language in the 1940s that the word fascism has lost all meaning as a descriptor because of its overuse. So, I mean, they're saying democracy because that's, I would actually say something a bit sharper. It is very common for those who seek authoritarian rule to claim that they are coming to ward off against anti-democratic threats. As a matter of fact, they have come, the opposition is basically saying, when we say democracy, we don't mean democracy like people get to vote things into law. We mean democracy like a system in which certain results are going to be produced. Now, they're talking about various kinds of rights protections. The problem is the Supreme Court is not a great protector of rights. They shut down an opposition radio station. They have changed the status quo in a way to restrict religious observance in public by the ultra-Orthodox. So clearly it should be enough to protect minority rights, to have a Supreme Court whose members are, the one who, to protect minority rights, the Supreme Court does not need to strike down its own colleagues. If so, then America is not a democracy. What they're saying is America is not a democracy. What they're saying is Justice Scalia was a partisan political hack, Ruth Bader Ginsburg is a political hack, and the only honest people in the world are the justices of the Israeli Supreme Court, who all conveniently agree with each other on these issues. So I think that's absurd. And I want to make another point. If they're saying that being appointed by politicians makes you dependent on the politicians, being appointed by judges then would make you dependent on the judges. And that's in fact much worse, because the judges aren't going to change over time. Politicians at least change over time, so you're dependent on different politicians, and you can have different factions on the court who can call each other out. And right in America, for a long time, the current right-wing majority was a minority, and their dissents were very important to the public. In Israel, what this promotes is a culture of basically obsequiousness to the Supreme Court that starts not just amongst judges, but lower court judges who want to be promoted.
Right. Well, that was the Bar Association. That was the argument against keeping the Bar Association on the committee, because they would be seeking to curry favor with the judges because they want to become justices themselves, and therefore they would never buck the opinion of the justices.
Of course, the Bar Association has voted almost exclusively with the Supreme Court. And I just want people to understand, that's the status quo. The status quo is the judges combined with representatives of what would be like the ABA in America get to pick primarily the successors to the Supreme Court.
So another beef about the proposals is that the ones that are front and center now are really designed to help the prime minister with the legal cases that are pending against him. A few days ago, a law was passed in the Knesset that would eliminate the ability of the court to remove a sitting prime minister and relegated that role solely to the Knesset. Last Thursday night, the prime minister referenced that law by saying his hands were no longer tied in terms of being involved with judicial reform. The next morning, the Attorney General said that he was still barred from involving himself in judicial reform, as it would be, per the Supreme Court's ruling, a conflict of interest. Eugene, could you elaborate on what you think the Prime Minister was referring to when he said that he's no longer bound, or his hands are no longer tied? And what possible impact would these laws have on the legal cases that are pending against him?
These laws have absolutely... First of all, let me start with the impact on the legal cases. It's absurd. He is being currently tried. He has been on trial for many, many years. So many years, it would be absurd in America. We're calling so many witnesses who often recant their proffered testimony and say they were coerced by the prosecution. This whole thing would have been thrown out in America. Numerous witnesses have come up and testified that the confession that they made implicating the prime minister was coerced by the prosecution, that they had a proverbial gun to their heads, and that several years later they recant their testimony. You can ask Judge McCasey. I think it would be very hard for a case to proceed after multiple such setbacks in the United States. But this case is proceeding for many years. And the reforms have nothing to do with this case, because we're talking about appointments to the Supreme Court, not appointments of the judge who is already presiding over this case. That judge is there. There is a case. It is being presided over. It will finish. So the argument is that if he is convicted in a year or however many years this will take, and he brings an appeal to the Supreme Court, maybe one or two of the judges on the panel might be judges that he depicted. That's not an argument in America, right? In an argument in America, judges on the Supreme Court are not considered somehow incapacitated from dealing with a president simply because they appointed him, but also it's a fairly far-fetched scenario. None of these things have anything to do with criminal law, none of these reforms. Mm-hmm. Now, at the same time, the Attorney General, as soon as Netanyahu took office, launched what I would call decapitation attack on the government, declaring that the Prime Minister has a conflict of interest and is thus incapable of dealing with these issues and is partially incapacitated, basically, under Israeli law. So the amendment, so for the first 2 months of this matter, the opposition with Pete Gantz could get up and speak about this, and the Attorney General had, without any judicial procedures, just through a 2-page letter, basically fired the Prime Minister in part, prevented the Prime Minister from being Prime Minister from the single most important issue in the country. So now they passed a law saying that you can only declare a president incapacitated, like under the, I forget which amendment, 20-something amendment?
25th.
Yeah, only if they're actually like physically incapacitated, not because you think they have a conflict of interest. Now, needless to say, the Attorney General has a similar, massive direct conflict of interest because her own powers would be affected by some of the proposals. So with that law in place, I think Netanyahu felt safer to proceed. Though in my view, he should have ignored this Attorney General order from the beginning, because since when can an Attorney General fire a Prime Minister about the most important national issue? And I think that's like, just, if we're talking about abuses of the system, that's the absolute clearest example.
Michael, does this all strike you as something like out of Alice in Wonderland? It must sound rather absurd to you, given an American perspective.
It really does. I mean, it's. I feel as if I've stepped through the looking glass. The question of when or whether the Prime Minister can be incapacitated if his trial ends adversely to him is entirely hypothetical. And he was elected, as I understand it, on a platform that included putting in place certain of the proposals that we're talking about now and that are being considered. For the Attorney General to say that, notwithstanding that he was elected with that platform, he cannot do what he said he was going to do, or he cannot help do what he said he was going to do, is simply otherworldly. Right. That's what he was elected to do. And talk about anti-democratic. I mean, that is the nullification of the outcome of a democratic election.
Right.
And I read one thing, and also it's not like, there was some kind of fraud upon the public, that he was indicted, only after he has been now elected, I think 3 times since these charges were
brought. Cottage industry in this country to investigate Netanyahu. There have been 19 investigations of him, and it's like I say, it's a cottage industry. So I want to move to another area of a lot of contention, and Eugene, you pointed this out, and that is that there has been no negotiations here, and one cannot shake one's own hand. You can't negotiate with yourself. Simcha made some unilateral changes to the proposal for judicial selection, but the sense among the interested public is that there has been no conversation. There's been no meaningful negotiations that have gone on here. Eugene, is that accurate? And what do we do about that? You have now some members of the coalition getting afraid because of public reaction. They're calling for delays. Now, you made a very interesting point. Delay is tantamount to ending the process. So is it realistic even to consider delays? Or are they just another way of, sort of politely sidelining the entire initiative?
Yeah, I think mostly the latter. There's a reason the opposition has said they want, the whole thing frozen before they talk. Because once legislation loses its momentum, it basically gets derailed. It also allows the opposition more time to mobilize. The protests continue. The opposition is interested in one thing. Now, it's not a bad thing for it to be interested. It's traditionally the goal of the opposition in parliamentary democracy. The opposition is not interested in compromise. They're interested in bringing down the government. That is, of course, the role of the government, of the opposition. What is tragic is that they are missing an opportunity for a true national consensus on important issues, and that they seem willing to endanger the economic and military health of the country to bring down the government, which is something that has never been done before.
Right.
But also, why should they compromise? Under the current system, they have all the power. What's the reason to compromise, right? Now, the one reason would be, if you don't compromise, the government's going to pass this legislation anyway. But they say, but we're going to have a mutiny, right? And we're going to have the army not listening to the government. So in the end, we have and the Supreme Court's going to strike down your reforms, and the army is going to take our side. So why should we compromise? I saw in the comments many people said everyone agrees on the need to reform. I'm not sure about that. I think everyone on the right and center agrees on the reform, on the need for reform. Even members of the opposition might intellectually agree. But there's a difference between agree and allow for it to happen, right? Those benefited by the current system will not willingly allow it to be changed.
No, the mantra is, I'm in favor of reform, but this is too much, this is too fast. We should be more deliberate, we should be more incremental.
About compromise. There have been negotiations. You asked about negotiations, I will say. There have not been negotiations really with the opposition because they don't want to negotiate. The political opposition. So I'm saying the politicians. There have been significant negotiations by representatives of civil society, think tanks, including mine, opposition think tanks, prominent jurists associated with the left, Professor Daniel Friedman, Tel Aviv University professor, former justice minister, definitely a member of the left, but someone who does understand the need for reform. He issued a compromise proposal. My think tank, based on negotiations with other counterparts, other top, let's say, professors on the left, issued a reform proposal, all of which are significantly softer, all of which I think could have been a great basis for a political compromise if the opposition politicians wanted to compromise. Instead, we got Herzog's proposal, which actually only makes the current situation, codifies the current situation, and wants to make it worse.
So, Justice Minister Levin said that if the court were to, if selection process is passed and the court throws it out, overrules it, he's inclined to move forward regardless. And yet, a week and a half ago or so, former Attorney General Mandelblit said that the Supreme Court was on the verge of, quote, issuing an injunction against any legislation. And now, so even if they don't issue an injunction, they just wait until something is passed, and as you say, they overrule it, aren't we now at the impasse of all impasses? Isn't this like, confronting the existential cliff? What happens at that point? How do we pull back from that kind of a cliff, or we don't?
I think there's no roadmap for that cliff, which is why it's so important, which is why it's tragic that members of the opposition are signaling to the court that it is legitimate to veto. And I'd ask Judge McCasey if this would even be conceivable in the United States, to veto a proposition about the composition of the committee that appoints the judges, and to say it's against Israel's general democratic principles.
The entire situation is inconceivable under the system that we have, because it includes, as I said before, several steps that require participation by the political branches. The president nominates, the Senate approves the appointment of judges, and so this kind of situation could never develop. In addition, the court operates under principles of justiciability and will not decide what it has called political questions. And of course, this is the ultimate political question. So the prospect of something like this being brought before a court in the United States is impossible to imagine.
Yes. Well, again, a lot of this must seem incredibly absurd from your perspective, and it's the kind of thing that, like you say, Eugene, we don't have a roadmap for, and what strikes a lot of us as really very dangerous is the willingness of former leaders to, in effect, be willing to countenance burning down the house in order to stay in power, maintain power, get back into power. And it seems profoundly irresponsible. It seems profoundly disregarding of the of who they have been, guardians, custodians of Israeli democracy. We're at the top of the hour, and I know, Eugene, you have to go to yet another appearance. So I would like to ask each of you, is there a salient point or two you want our viewers to take away with them from this discussion? Michael, I'll start with you.
I think what they should take away from this discussion is that unless you have a system that allows for some democratic input, obviously here I mean democratic with a small d, that allows for some democratic input into the appointment of judges, then you're going to have a system that is increasingly illegitimate to people who are adversely affected, regardless of their political views. The court has to have some relationship to the citizens whose cases it decides. That relationship is established the way I described before. Yes, they exercise their independent judgment, but only after they go through a political process. And I think that is responsible in large part for why the court is held in high esteem, why courts are held in high esteem. They also decide cases based on objective standards. If you don't have both of those, then what you have is tyranny on one side or the other.
Eugene, any thoughts?
Yes, as we go into the next few weeks, I think the one thing I would just generally caution people is that the media coverage of this is vastly disconnected from the reality, and I think one reason is fear sells and fear makes headlines. So people saying like end of democracy is much more dramatic than we have some suggestions to improve separation of powers in Israel. Be careful in terms of like how you draw your judgments. And we're entering truly testing times for Israel. I pray it comes out well.
Okay. Well, I want to thank you both. And I want to thank our viewers, of course, and our attendees. And while we did not take questions, I see there were comments, and that's great. But I would hope that the information that came out and was shared today answered a great many questions and concerns that you all might have. Friends, in less than 2 weeks, we will be celebrating one of our most beloved holidays, Pesach, Passover, where we thank God for bringing us out of Egypt and beginning the process of making us into a nation. This Pesach, I hope we would spend some time thinking about what kind of a nation we want to be. Speaking personally, I would want us to be the nation that remembers and then embraces who we are. We are the people who charts our own path, that defies all expectations, that somehow perseveres and succeeds in the face of all conventional wisdom to the contrary. We are also the people who are capable of setting aside our differences in order to find common purpose and to maintain our much-needed unity. The case for judicial reform, as you've heard today, is a compelling one. It needs to be made. Changing the way justices are chosen will ultimately result in a more democratic government, with a judiciary more trusted by far more of our citizens. At the same time, our leaders need to make the case that rebalancing the court or the other proposals does not mean diminishing rights nor hampering freedoms. No Knesset is interested in creating a theocracy, nor in hamstringing the free expression that has helped make Israel into a light unto the nations. While the Knesset will be in a month-long recess starting next week, the effort to explain, to reassure, and to unite our people must continue unabated. I believe in us. I believe we can accomplish what needs to be done. Thanks again to our panelists, to our co-sponsors, and most especially to our listeners. Best wishes for a good week, and of course a Pesach Sameach to us all. Goodbye, Lihitraot.